Good afternoon, or good morning. Good morning. My name is Elizabeth Anderson, and I'm the Executive Director of the American Society of International Law. It's my pleasure to welcome you today to Tiller House, our headquarters. Those of you who are regular attendees, please come in. I think you've got the very last. Oh, there's one more seat. At our events, we'll recognize that this one we've shifted the choreography a little bit in that we're going to have the discussion first and eat second. So you'll have to stick around to the very last for the goodies. I'm going to turn to Andrew Solomon from the Brookings Burn Project and to really do all the introductions of our subject. Please come in. Yeah, you might want to come in through the back. And to introduce our speakers. So I just want to say a word of welcome and appreciation. It's very much in ASIL's tradition to contribute wherever we can to the development and codification of international law and the study of best practices in implementation of international law. And I can think of no better example of that work than our collaboration with the Brookings Burn Project over the years on the development of the guiding principles on internally displaced persons. And we're very grateful to them for reaching out to us and involving us in this project, letting us share a little bit of the glory, quite frankly. We're honored to be publishing the volume, very thick volume, on your chairs here on incorporating the guiding principles into domestic law. It's an extremely valuable resource, will be, I'm sure, for years to come. And happy to be hosting this event to roll it out today and focus on the particular challenges posed by climate change. I want to thank the editors of this volume and also one who's not so prominently named on the cover but has worked very hard on this. That's our Tiller House fellow, Prithi Deshmukh, who's hiding in the back there but should stand up and be recognized for her hard work in ushering this publication through to the very end here. Without her help, it wouldn't be on your chairs. Those of you who are not members of the Society, I want to encourage you to join so that you can be invited and come to these events regularly. And I also want to be sure that you've noted the flyer on your seats for our annual meeting at the end of March. It is going to be a great gathering of interested scholars and practitioners in international law discussing just about everything under the sun and not to be missed. In terms of our logistics today, those of you who are interested in continuing legal education credit for this event, it is certified for such credit in Illinois, Pennsylvania, New York, Florida, and Virginia. So if you need to sign in, though, in order to obtain that credit. And if you have, I think there are lists downstairs where you can sign in. If you have any questions, please see my colleague, Ben Brockman-Haw, who is also standing in the back there and can help you with that. And I guess with no further ado, I'm going to turn it then to Andrew to introduce our program. Thank you very much.
Okay, thanks, Betsy. It's indeed a pleasure to be back here at Tiller House with you and so many colleagues. I think I'd like to just get us started by first thanking all of you for attending and for your interest in today's topic, the human rights of persons who are displaced from climate-related phenomena and natural disasters. I think the size of today's turnout, and I see that we're already sort of into overflow, is really a testament not only to the importance of our speakers, but also, at least to me, it's an indicator of the growing awareness and concern over the seriousness of climate change and interest in efforts to think through or assess how best to mitigate and adapt to climate change. 2 decades ago, the Intergovernmental Panel on Climate Change, in its first assessment report, identified some of the major impacts of climate change, including its impact on human mobility and migration. And in retrospect, I think they were quite prescient and perhaps even correct. Today, we see estimates of individuals who are forced from their homes and communities on account of climate-related phenomena, whether it's drought, desertification, deforestation, or rising sea levels, as well as natural disasters. Numbers ranging anywhere from 25 to 50 million persons for this year, according to some estimates. Similar estimates, including those of United Nations and other experts, suggest that the numbers of persons displaced as a result of climate change and climate-related phenomena could reach into the hundreds of millions by 2050. So this is clearly a pressing problem. I would also, just by way of background, draw your attention to a recent study published by the Norwegian Refugee Council, which suggests that the number of persons displaced by natural disasters, climate-related phenomena, has now overtaken armed conflict as the major trigger of internally displaced displaced persons around the world. So for international lawyers, such as many of us in the room, but also for policymakers, for development specialists, for humanitarians, the displacement of millions of persons around the world as a result of climate-related phenomena poses a variety of questions and challenges. And fortunately, we have with us here today two leading experts in this field who can help us think about these challenges, particularly those related to the normative framework for protecting and assisting displaced persons. Our first speaker today is Walter Kalin. He's a legal scholar and a professor of constitutional and international law at the University of Bern in Switzerland. Since 2005, he has served as the United Nations representative of the Secretary General on the human rights of internally displaced persons. But he's really been involved in issues of internal displacement for well over a decade, having chaired a committee of international legal experts that developed the guiding principles on internal displacement, and also having drafted and authored many articles and books on this subject, including the annotations of the guiding principles, which have been published by the American Society of International Law. Professor Kalin also served as a member of the United Nations Human Rights Committee, and I'm pleased to note that he also co-directs the Brookings-Byrne Project on Internal Displacement, where I work, and is also a member here at the American Society of International Law. Professor Kalin will get us underway with remarks of roughly 35-40 minutes. He will then be followed by our discussant, and I'm very pleased to be able to introduce Dinah Shelton, a professor of international law as well at the George Washington University Law School. She is a prolific author of numerous prize-winning articles or publications, numerous articles on issues of international law, human rights, and international environmental law. In addition to her work in academia, she's also a legal consultant, or served as a legal consultant to a variety of organizations such as the United Nations Environment Program, the WHO, the European Union, and also the Organization of American States. Just last June, she was elected to the Inter-American Human Rights Commission and has just recently taken that position here in the last month in January. So I can think of no two people better qualified to speak about the issues of climate change, the human rights, and the situation of displaced persons around the world than Professors Kalin and Shelton. So with that, I will turn it over to Professor Kalin.
Thank you very much, Andrew. Thank you very much, Betsy, for the very warm welcome. For me, in fact, it's really a pleasure to be here for several reasons. First, I think it's a very good way to celebrate my 25th year of an ASIL member. Second, I'm very, very pleased that, again, we could cooperate on editing, publishing, bring out a book, this time on the incorporation of the guiding principles into domestic law. The big book you have received The annotations were mentioned. Another noteworthy publication at that time was studies I edited together with Roberta Cohen on the compatibility of domestic laws in South Caucasus, Azerbaijan, Armenia, Georgia, with the guiding principles. It was a publication that had an impact on the field. In fact, in all the three countries, the publication meant that their laws and policies were adapted, so it really was going beyond academia. And as regards the annotations to the guiding principles, I think ASIL should be very, very proud. This is the only publication, the only academic book I know of that has become legally binding.
Walter, can you use the mic? This is being recorded.
Okay. To my knowledge, this is the only academic publication that has become legally binding. Because within the framework of the peace process in the Great Lakes region in Eastern Africa, they adopted in 2006 a protocol on internally displaced persons, on the protection and assistance for internally displaced persons in the Great Lakes region, obliging states to incorporate the guiding principles into their domestic law. And there's an article saying that these guiding principles have to be interpreted and applied in light of the annotations published by the American Society of International Law. Okay, so it is a big pleasure. It's also a pleasure to talk about a very timely topic, climate change, displacement caused by climate change, and the legal challenges for international law. This was announced as a rights-based approach to climate change-induced displacement. I've changed a little bit the title because the first part is not about rights-based approach, but at the end we'll move to that, so it's not really a big change. Of course, talking about this issue starts with difficulties regarding how should we call these people who are displaced in the context of climate change. Very often they are called climate refugees. If you talk to UNHCR, they don't like it at all. They say refugees are refugees as defined by the conventions. These people are not persecuted. Their governments usually don't have anything against it. Don't call them refugees. Are they climate migrants or environmental migrants? That's what IOM says. Some of us have difficulties because in social sciences it's accepted migration covers both voluntary and forced migration. But these are not the legal terms. We have just one instrument on migrants that is legally binding. That's on migrant workers, and that's very clearly voluntary migration. And there is some fear that if we're talking about environmental migrants, the message is, well, in fact, these people could stay home. Why should we really bother too much about them? So, no consensus on the terminology. There, I think, is consensus that climate change as such does not displace anyone. But some of the effects of climate change are displacing people and will, that's what the scientists tell us, increasingly displace people as a consequence of sudden onset disasters, windstorms, flooding. They always have been existing, but their number, we are told, will increase as a consequence of global warming. And others are displaced as a consequence of slow onset disasters, rising sea levels, groundwater getting salinated, salty, desertification, etc. We also know some of this movement is and will be voluntary. Some of it will be forced. The big question is where to draw the line, because in real life there is a clearly grey zone. That's a challenge for us lawyers, how to define where to draw the line, and they will address that. And we also know that some of this population movement is and will take place inside a given country, and some of it will be cross-border. What is very important to see, people tell us who are studying these things, there is no monocausal relationship between the effects of climate change and displacement and voluntary migration. The causalities are very, very complex. There are different reasons. Poverty is an important reason. Rich people have much more resilience, can stay, whereas those who are very poor have to go early. Discrimination is an issue. If you're already marginalized, then it doesn't take a lot to make people move, whereas those who really control the situation, are in power positions, again, will stay much, much longer. So talk about degrees of increase of world temperature will directly lead to such and such numbers are very, very problematic. We have to look at the multiple causes, but still it is an element. It's an element that I think, from a legal perspective, is quite challenging for states. States already have agreed and are in the process of agreeing about additional obligations that they have to address the causes of climate change, which is the emission of greenhouse gases. This is about so-called mitigation. This is about the UN Framework Convention on Climate Change, the Kyoto Protocol, what was in the forefront of the discussions in Copenhagen, a conference that failed, but it's not the end of the process. It will go on. The challenge is there. But we'll see what will come out. This is not the topic of my presentation. It is very clear to everyone that even with the best mitigation measures, there still will be effects of global warming. There is also some disagreement about whether it's really just man-made, whether there are also natural causes. Whatever it is, it's a reality that cannot be denied. And even if it's not caused entirely by our behavior, still one has to deal with the consequences. And that's about reducing risks created by climate change vulnerabilities. This is called adaptation. Adaptation in terms of disaster risk reduction. The instrument here is the Hyogo Framework for Action, a non-binding instrument, but still lots of activities going on in many countries to take adaptation measures, particularly focusing on reducing the risks. In theory, and this was kind of the approach until very recently, if you do invest enough into mitigation, invest enough into adaptation, then everything is fine. Of course, in theory. In reality, everything is not fine because there are these consequences. Andrew has just mentioned figures, an increasing number of people displaced by the consequences of natural disasters. So I feel a third aspect is, a third challenge for states is addressing the consequences. This is about protecting individuals affected by the effects of climate change, whether or not displaced. I just will focus today on those who are displaced, but let's not forget the other ones. This is about humanitarian action. In legal terms, this is very much about human rights law. We do have some idea on possible scenarios, even though we don't have anything really specific and well grounded on figures. And what we distinguish are 5 different scenarios that do or may trigger displacement. First, the sudden onset disasters that are linked to climate, the hydrometeorological disasters, that's flooding, that's hurricanes, that's landslides, that's also thawing of permafrost in higher areas, like in my own country, Switzerland, where we start to have some problems. Some of our nice mountains starting not to fall apart, but becoming much more unstable with consequences of a negative effect. Very big consequences of thawing of permafrost. In the north, Inuit communities are affected by it, just to give one example. Although this is not sudden onset, both of them are already slow onset environmental degradation, slow onset disasters. Here I mentioned the three typical ones. The big debate right now is about the so-called sinking small island states. Those low-lying islands that will not sink, rather will be submerged because of rising sea levels. This is also a slow onset disaster, but of a different category, because here it's not just part of the country that is affected, but in the long term it might affect the whole state territory, meaning that in the end a whole state disappears from the map of this world. Relatively small numbers of people involved, but in terms of consequences, extremely serious. Fourth scenario, again, not the very huge numbers, but particular legal challenges involved. That's situations where governments say, people, you can't go back where you came from. It's just too dangerous. To give you an example, I visited 1.5 years ago Mozambique, where they have increased flooding in the river valleys. They always had them. But instead of once per decade having a real serious flooding, they have it now every second year. And the government says, we can't save these people every second year. We can't rebuild the infrastructure. You have to move away. We are going to relocate you. So you can't return. It also can be preventive evacuation, not just for a few days, but for longer times or even permanently. So increased need for governments to designate areas as high-risk zones where people are not allowed to leave. And finally, people may be displaced as a consequence of conflict, armed conflict, violence, over diminished resources. If there is less water, if there are less grazing grounds, what's happening is competition for very limited resources. And if these conflicts are not managed well, they will lead to conflict, to violence, again displacing people. We know that it's likely that climate change induced population movements, both voluntary and forced migration, will increase. It is likely, looking at the present situation, that most people will not go abroad but remain within their own country. But already now some people are crossing borders, and this may also increase. As I said, existing models do not allow to really predict the magnitude and exact locations. There are indications, there are scenarios, but it's not very solid models. If I'm talking to the climate experts, they say, no, we can't give you the prediction that here on that location, people in the year 2050 will have to move. It's much more complex, but we can't be quite sure about the big trends. What we also know is, in terms of migration law, the law on displacement, also the policies related to it, all of this will not be exactly the same for each of the 5 scenarios. It makes sense to look at the 5 scenarios, and that's what I would like to do from the perspective now of rights, of protection for these people. What I would like to identify is what bodies of law are protecting the different categories of people. Sudden onset disasters. Those who remain within their own countries, very clearly they are internally displaced persons as defined by the UN Guiding Principles on Internal Displacement. The UN Guiding Principles on Internal Displacement are not a binding convention. They are a document that is based on existing hard law that tries to restate what is implicit in the general guarantees of international humanitarian law, not relevant for us, international human rights law, and put specifically into words what the meaning of these general guarantees is in a displacement context. As was mentioned, the guiding principles were developed by my predecessor, Dr. Francis Deng. I had some role in the preparation of these guiding principles. In the meantime, they have gained quite some authority. The World Summit in September 2005, where all the heads of state and government assembled in New York, recognized unanimously the guiding principles as an important international framework for the protection of internally displaced persons. I mentioned the Great Lakes Protocol, making binding these guiding principles. The new AU Convention on protection and assistance for internally displaced people in Africa is very much building on the guiding principles, reflect much of its substance, some of its wording. So there we have something. And I do feel, because we have a growing consensus on people displaced by natural disasters being internally displaced persons, it doesn't make any sense from a legal perspective to try to develop new notions, new definitions on these people. The guiding principles do explicitly say an internally displaced person is someone who is forced or obliged to leave or to flee his her home or place of habitual residence for a variety of causes, including man-made and natural disasters. And again, that's good. We don't have to enter into a debate to what extent climate change is man-made and to what extent it's natural. It's covering both. The African Convention and the Great Lakes Protocol both cover natural disasters and man-made disasters exactly the way the guiding principles do. So I would say we have the normative framework in place. We have to strengthen it. We have to incorporate these norms into the domestic laws and policies. And this is what this book is very much about, and what we are trying to do now in several countries, working with the governments. The big problem is with those crossing international borders. They are clearly not refugees as defined by the 1951 Refugee Convention, by regional instruments, because they are not persecuted, they are not victims of violence. So one can make, maybe we can leave it to the discussion, make some arguments that some categories might be covered, but it will be just very marginal. Most people do not qualify as refugees. They do not qualify as migrants as defined by the 1990 Convention on the Rights of Migrant Workers and Their Families, because there it's clearly saying a migrant worker is someone looking for work. The economic reason is the main reason for moving. These people do move for other reasons. Of course, these are all human beings, so they are protected by human rights law. Trouble is, for foreigners, human rights law does not contain any guarantees on admission. So these people don't have any guarantee that they will be let into a neighboring country or any other country, that they can stay there. That's the big legal gap. I'll come back to how to fill that gap. Slow onset disasters, environmental degradation. What we can assume is that first, many people who in a way could continue to stay there will move voluntarily, both inside their own country but also cross-border. If I were a farmer somewhere in an area where it's likely that in 20 years all of this will be just desert, I would think about the future of my kids, and I might decide it's better for my family to move out this is not a place where there's a future for my children, even though right now I still can make a living. Typical voluntary migration. Again, these people, of course, as human beings, are covered by human rights law. Internally, they can invoke the freedom of a movement, liberty to choose one's place of residence. Under, for instance, Article 12 of the Covenant on Civil and Political Rights, a right that can be limited, but still they do have some protection also regarding their movement-related rights. But cross-border, again, no right of admission. It's up to the sovereignty of states, unless you have some free movement agreement at the regional level, like within the EU, or a sub-regional level, for instance, ECOWAS in the African context. To the extent that later these people really have to move, they cannot remain, they become displaced. It's forced migration. If they remain inside their country, no problem. IDP's guiding principles on internal displacement with all the human rights law behind it, so it's human rights protection. Cross-border displacement, the same problem as with those that are moving as a consequence of a sudden onset disaster, the big gap regarding admission, right to stay. And here the big question, where to draw the line. I will come back to that, but that's something that is not clear from a legal perspective. The small island states, again, I think first people will start to move away. In some countries we already see it, more migration away for different reasons, but this being one of the reasons, do we really have a future? Here it can be internal, it can be cross-border, because it's voluntary. We have the general human rights protection. Later, when it's just becoming too difficult, more and more land being eaten away by the sea, the soil becoming salinated, crops failing, drinking water no longer good enough for human consumption. People will be displaced across international borders. And again, no right to admission. A very big gap because, unlike in other cases, these people don't have a choice than to move to another country. They can't remain within their own country when it's just becoming too small. Very often in discussions I hear these people are becoming stateless. I do have my doubts. If you're looking at the Convention on the Rights or the Status of stateless persons, statelessness is defined as being without a nationality, not being without a state. And just because people have to move away, they do not necessarily lose their nationality. There still might be a government that maybe holds on to some part of the former islands, has a more or less symbolic presence, but it's still a government that will issue birth certificates and passports. Of course, we all know the theory about the definition of what a state is. Territory, population, and government able to deal with the rest of the world. So from a very traditional, formal perspective, one could say no territory, no state. But then what is no territory? We always can build up some small part and have some presence and build some dikes, etc. And second, who will determine? Will any of these governments say, we lost our territory, that's why we are giving up our statehood? We're sorry about it, but goodbye. Will anyone there in the UN General Assembly to say, this or that state should be excluded from the organization because it has lost its territory? We do have precedents in international law of entities that once were states are still subjects of international law. It's the famous Maltese Order. It's a bit, marginal in international law, but it's an interesting model. If there is a consensus that an entity continues as a subject of international law, even if the territorial basis is lost, then that's the way it is. So it's very difficult to predict what is going to happen. But I don't think that we can determine on day X, after the big storm, carrying away the last of the 3 palm trees, people are becoming stateless persons. So the big challenge from a legal perspective here is to clarify the legal status of persons who are living abroad, even though they still might have a nationality, but not a place to go back to. And the big legal challenge is what's happening to their country of origin in terms of the identity of that country. Can it somehow be preserved, even if the original island is no longer suitable for human habitation? Fourth scenario, forced relocations. If it's done inside the country, we have the guiding principles, human rights law. There's a lot of soft law on development-induced relocations, how people should be relocated. The World Bank has developed standards, the Asian Development Bank, other development banks. I think there you have a lot of good things within the context of the UN Human Rights Council. My colleague Milun Kotari, who was until recently the Special Rapporteur on the right to adequate housing, has developed guidelines, standards on relocation of people. So that's, again, we do have here hard law, soft law that can be applied. We have one very specific, I don't think that people will be forcibly relocated across international borders, but the big problem here is kind of a tension. People have freedom of movement, including the right to choose their place of residence, which means the right not to move, and that's an important right. At the same time, governments have the duty to protect life under the right to life, and to balance these rights, that's not very easy. I'm just coming from a discussion with the OAS where this was brought up in the context of indigenous peoples who fear that if you do too much in terms of evacuation plans in the context of natural disaster, this will just be a way to grab their land, to get them out. And that's just an illustration of these tensions. Again, lots of things unclear here that need further legal research. Last category, not such a big problem. Unrest, violence, armed conflict. Those remaining within their country are internally displaced persons, guiding principles. Those who cross are refugees, be it under the 51 Refugee Convention, under regional instruments, or people who receive subsidiary or temporary protection as part of refugee law and policies. Refugees also could be, I was mentioning that, those victims of natural disasters who flee not only because of the natural disaster, but also because their government is consciously withholding or obstructing assistance in order to punish them, in order to discriminate against them based on their race, religion, ethnic origin, the relevant grounds under the 1951 Refugee Convention. But as I said, this always will remain a small group. So, next point, the big challenge. What to do about those who cross international borders? How, here first, to distinguish between those who, as voluntary migrants, don't really have a right to admission, and those who are in need of protection regarding admission and stay because they have been forcibly displaced. What about the obligations of receiving countries? What I propose, and I just can introduce it here, would really go into all the details, is a kind of what I call returnability test. One should not so much look at what was the situation when people left, but more at what is the situation when people arrive. Can these people be returned or not? And there are different reasons why people cannot or should not be returned. There are three categories of these reasons. There might be situations where it's simply under international law not permissible to return a foreigner to the country of origin, to reject him or her at the border. Here a basis is the case law developed by the first European Court on Human Rights, later the Inter-American Court, and the UN Human Rights Committee on provision of forcible return based on the provision of inhuman treatment. You're all very familiar with the case of torture. That's Article 3 of the Convention Against Torture, but there it's limited to torture. We're not talking about torture. But the case law under the Human Rights Conventions is broader. Wherever it would be inhuman to send someone back to the country of origin, because what is going to happen to that person? The person, for instance, will die, will be killed, will face very, very severe health consequences. If looking at the fate of the person, it would be inhuman to really push that person into that situation, is absolutely prohibited under Article 3 of the European Human Rights Convention, Article 7 of the Covenant on Civil and Political Rights, and the equivalent provisions in the other regional instruments. Sometimes it's not possible to return someone because return is not feasible. It's simply not possible to send a person back. For instance, because right now there is no transportation. It's still flooded, the roads are closed, the airports are closed. Sometimes, and for not just a few days or weeks, like in the first case, it may be legal reasons, the country of origin saying, of course we are ready to take our citizens back, but we doubt whether this person is a citizen of our country. He doesn't have any, or she doesn't have any valid travel document, no ID cards, nothing. So prove us, give us evidence that this is our citizen, and only then will we be ready to take the person back. And that's kind of a natural reaction of a country under stress, already having difficulties to deal with the population that is present. They are not interested to receive lots of people returning. So this would be a legal obstacle to sending these people back. But then there also will be cases where, from a humanitarian perspective, it would be simply unreasonable to expect a person to go back. For instance, if there is a lack of protection or assistance, or the protection and assistance provided is way below international minimal standards, how can you expect a person to go back under certain such circumstances? It can be because of some attributes of the person concerned. The person with disabilities will have much bigger problems to face a post-disaster situation than a very healthy, strong person. Again, it might not be reasonable. Someone who cannot get medical treatment that is necessary because all the hospitals have been destroyed, and so on and so on. So I do feel this is providing criteria to draw the line between voluntary and forced migration, and it would offer an opportunity for legal provisions, not an opportunity, a kind of a concept for drafting legal provisions to say these are the persons eligible for admission for temporary stay or even for permanent stay where these will last. And in fact, we do have some examples already in domestic legislation. Here in the US, you have a very interesting temporary protection TPS status in your Immigration and Nationality Act. As you can see, environmental disaster resulting in a substantial but temporary disruption of living conditions. The foreign state is unable to really fully deal with all of its national, and then the country concerned requests such designation. This was applied after Hurricane Mitch for people from Central America, Honduras, Guatemala, etc. The Scandinavian states have introduced temporary protection provisions for refugees, but they say that the same protection can be granted to persons displaced by disasters. That's something one could build on. At the international level, I think the UN Framework Convention on Climate Change, it's 3 C's, not 2 C's, sorry. Framework Convention on Climate Change, that's a typo. This is a debate now within the Copenhagen, post-Copenhagen process. What we from the humanitarian human rights side of the UN tried to do was to get an article into the new instrument that would acknowledge that migration displacement are a consequence of climate change that needs to be addressed within the framework of adaptation measures and is eligible for money from the Adaptation Fund. That international cooperation is important in the case of cross-border displacement. The text was kind of agreed, but the whole instrument failed. But I think we are there on quite safe ground, but we have to continue to lobby and fight. But that's just a principle. For the more detailed provisions and regulations, we need other fora, UNHCR, the Human Rights Council, IOM. It's an open question. I'm coming to a conclusion. I think we can safely say persons forcibly displaced by the effects of climate change who remain within their own country are IDPs covered by guiding principles, by existing and maybe future regional instruments. However, there's a big gap for those crossing international borders. And what I'm here calling for is to look at these population movements really from a human rights perspective and build laws and policies and new international instruments on those human rights instruments using, in that sense, a rights-based approach. Such a rights-based approach, at the minimum, would first recognize that protection and assistance for those displaced by the effects of climate change is not just an issue of mandates of organizations, of available money, of policies that can or cannot be used and implemented, but it's something that needs to be looked at from a human rights perspective. These people have rights to be protected and assisted from a human rights perspective, and they must be granted rights in the case of cross-border movements to be admitted to other countries and to be allowed to stay there as long as the dangers, etc., continue to exist. Second, we have to the rights-based approach would recognize that governments have the primary responsibility to assist and protect these people, but they have an obligation to incorporate their international human rights standards into their national laws and policies in a way that it really matters for people who are displaced in a natural disaster situation. Again, that's why I think this is a very timely publication. And third, rights-based approach would acknowledge the gap regarding cross-border displacement, the gap that from a human rights perspective should not be accepted, and therefore should recognize that there is a need to develop legal norms at the domestic and international level to ensure that those displaced across borders have the right to admission, have the right to be protected against being forced to return, being sent back to situations of danger and other grave problems for their rights. And with this, I've come to the end of my presentation. Thank you.
Thanks, Walter, for that very comprehensive and detailed discussion, not only of the triggers of displacement, but also the legal and policy frameworks and the gaps that exist and how to plug those gaps. So we now have Professor Dinah Shelton, who will serve as our discussant, and the floor is yours and the mic.
Thank you very much. It would be much easier to provide a commentary if I disagreed with anything that's been said, but I don't. So I'm mainly going to be perhaps re-emphasizing certain points and adding on some comments primarily on what various institutions are doing to try to fill some of these gaps, and particularly what the human rights jurisprudence looks like on some of these issues today. It is a topic that is very, very timely in being dealt with by a number of institutions, partly because there is so much crossover in subject areas. So you have the UN Environment Program because it raises environmental issues, the UN Development Program because it clearly impacts human development, the Human Rights Council, various other human rights bodies who are dealing with this from the human rights perspective. So we have environment, development, human rights, and I would also add state responsibility because there certainly is a concern that those who are suffering the most from these kinds of disasters tend to be in countries that haven't produced the problem, to the extent there's a linkage between climate change and natural disasters or environmental changes. This is certainly not a new issue if you've read Jared Diamond's book Collapse, and if you accept some of what he's dealt with, we could look back to Easter Island to see that when you destroy the carrying capacity of your territory, the people tend to disappear as well. Despite this, there are certainly those who retain doubts that there is anthropogenic climate change occurring, or that if it's occurring, there's any responsibility on any transboundary basis, or that it has a link to human rights. In November, I gave a talk at the University of Chicago on this issue, and they posted my talk, which was about human rights and the link with climate change. And some of the comments that came in said human rights people shouldn't be talking about climate change, only scientists should be talking about it, and it doesn't exist. And, well, you can imagine the Chicago School of Economics didn't think much about the issue either. But in any case, if we accept the science and we look at the consequences, and I would really recommend you look at the 2007 UNDP report that was on human development and climate change, because it is really very persuasive and very detailed about the types of consequences that are to be expected from climate change. What I really wanted to emphasize to start with is the disproportionate impacts and the disparate impacts that are predicted, and indeed one can already see because of pre-existing conditions. The example I give of this is to compare my situation as an internally displaced person in 1991 after one of the periodic huge fires that occur in California. They're seasonal. They're linked with Santa Ana wind conditions. They tend to be somewhat linked to the El Nino phenomenon, but if you watch the news at the end of every summer season and autumn, you will see the reports of great fires in the California hills. And then later on, you'll see them in Australia. So it's predictable that these fires are going to occur. So in 1991, in late October, such a fire occurred in the Oakland Hills and burned 3,000 homes and displaced everyone living in them and killed 28 people. So it was quite a large fire. But if you know anything about the Bay Area, you know that the socioeconomic status rises with altitude. And as a consequence, those burned out first tend to be the wealthiest. And by the time it got halfway down the hillside to where it was hitting the middle class, they had the fire under control. So what happened to people who were displaced by this? Many of them had friends and relatives in the area. But those who needed a place immediately to stay, as I did because I was on sabbatical in France at the time, I flew home and was immediately placed in the Claremont Resort and Spa, along with a number of other people. And we were given a very low rate, and I still have the bill on which it says, Dinah Shelton, distressed person. So there we were in the luxury spa in the Oakland Hills. My insurance company was waiting for me when I arrived off the plane the next morning with an immediate check to cover all of my expenses. They paid for the hotel. They paid my rent for a year to live in comparable housing, and they fully reimbursed me for all of my losses. So I rebuilt my house in the same area, on the same property. And then, as luck would have it, I moved and sold the house. 5 years later, it is up for sale for double what I sold it for. The community was entirely rebuilt, usually with much more elegant houses that still have the panoramic view from the Oakland airport up to Marin. And if you look at any of these sites online, you will see that this is an extraordinarily beautiful, vibrant community. Green Day lives on the corner of my street now. So that's what happened in the Oakland Hills. People had insurance. They had places to go. They were lodged. There was immediate response at the local, state, and federal level. Contrast that with Ward 9 in New Orleans after Katrina. If you look at that online today, you will see it is almost still a wasteland. Where were people lodged? In the Super Bowl initially, and then later in contaminated housing that was known to be contaminated at the time it was provided. So you have, and the vast majority of people who lived in Ward 9 were poor and were minority. So that type of thing happens internally, but it also happens globally, in that it is poorer countries, largely not responsible for greenhouse gas emissions, who are paying the price in terms of mitigation and adaptation. So the consequences of this need to be thought about in terms of what are the transboundary responsibilities of governments who have produced this large the amount of greenhouse gases. But now if we look at the legal framework that we have, in terms of mitigation, as long as we're dealing internally, there is a pretty strong legal framework there. And there's been a convergence over the last, well, I'd say especially since Rio, but even going back since the Stockholm Declaration in 1972, between human rights and environmental law. Now, most human rights instruments were written before environmental issues emerged on the international agenda, and they don't use the term environment. It doesn't exist, except in the African Convention and in a protocol to the American Convention. But this has not prevented cases from being brought to human rights bodies, invoking human rights when they have been impacted by the failure of governments to deal with environmental issues. And I'd mention in a couple of cases in particular. One is a case called Budayeva against Russia that came up in the European Court of Human Rights. And it was the first case in which the European Court really analyzed the preventive and remedial obligations of states in a case of a natural disaster. This arose out of a mining area in Russia that was prone to mudslides, largely because of deforestation and the mining that had occurred there. The government knew this because it was like forest fires in California. It came up on a repeated basis. In 2002, they had especially heavy rains. The government had built a mud dam to hold back waters that protected a particular village. But they failed to monitor the dam. They failed to check their warning systems that were available. And they failed to warn the villagers that problems with the dam would have been perceived if they had actually been doing the monitoring. The dam burst. The village was essentially buried. So there were property losses, but there was also loss of life. And the European Court broke the case down into two parts. What should the government have done ahead of the disaster, and what were their obligations after the disaster? And they found the government responsible for the loss of life because they had not monitored, they had not informed, they had not taken the preventive actions necessary to mitigate the damage. So in that case, they partly incorporated environmental standards to analyze what the duties of the government were, including the obligation to enforce their domestic laws, because they had a nice legal framework in place, they just hadn't enforced the laws, but also to enforce any international agreements to which they are party. After the fact, they said, yes, we will be fairly deferential to governments in responding to natural disasters. We can't put too strict a scrutiny in terms of what they've done. In this case, we are not sure that even if they had taken all of the preventive measures necessary, the mudslide that occurred could have been prevented because of the unprecedented rainfalls in that year. So we will not find them responsible for the property loss. It's not clear that they could have gotten the property out in time, but they were responsible for the loss of life. So that's one case in which the European Court of Human Rights has found the possibility of laying out for governments what their obligations are under human rights law in the connection of natural disasters. Another body in Europe, the European Social Charter, has taken up the issue in a different context because it's not dealing with a natural disaster, but dealing with the more slow developing types of harm that can occur. It was in the context of lignite mining in Greece. Lignite mining being something that produces greenhouse gases and that also produces waste that is quite hazardous to health. Miners and the local communities brought action against Greece under the right to health in the European Social Charter. What was interesting about this case was that in finding Greece responsible, again, for not properly informing, consulting, and taking the procedural dimensions necessary under human rights law, they made a finding that Greece was violating the right to health of these persons because they had not lived up to their Kyoto Protocol obligations. So that became the standard by which they judged whether Greece had violated the economic and social rights of the individuals in this case. So there is a fair framework, and there are institutions that exist both globally and regionally where these types of issues are being brought. There are some problems, though, even in this area. Under all the human rights instruments that we have, states have the permissibility of derogating from human rights in times of emergency that threaten the life of the nation. As far as I know, no state has invoked any derogation provision thus far, but it raises the question as to how to continue to protect civil liberties and other human rights in a period of natural disaster should a government choose, and one might think of a tsunami in Burma, to even engage in further repression through declaring a national emergency. Now, the human rights law would say they can only derogate from derogable rights, which are not the core ones, and only to the extent that the exigencies of this situation. That is, that there would be an ability to contest derogations that appear to be pretextual. But that is a question that is open. In terms of the forced relocations, we do have some case law in the inter-American system, and this may be why the Native Americans, or not the indigenous in the hemisphere, are particularly concerned about forced relocation, because it has been used. And one of the major instances where this was done was in the case of Nicaragua during the conflict between the Sandinistas and the Contras, when the mosquitoes were moved from the eastern part of Nicaragua, ostensibly for their own protection in case of armed conflict, but it did appear to be more of a land grab in the aftermath, and the Inter-American Commission was asked then to look into that. The transboundary issue is, of course, the most difficult, and that is where we have the greatest gap. One of the problems I see in the long term is not only about the right to get in, but the rights once you get in. Most human rights instruments do not afford aliens the same degree of rights as are afforded to citizens. The due process that's available in case of being excluded or deported is much less than in a criminal case. There's a growing body of law in terms in this respect, but I do think there are gaps in the law there. And one question would be the possibility of using this issue to ratchet up protections for aliens more generally, which I think would be terrific if that could happen. Finally, this is an area, as I say, with this interface that a lot of different institutions are getting involved in, and also academics. And there are at least two draft conventions that have been worked on by different groups. One based in Limoges, where there is a draft convention on environmentally displaced persons, and a group in Australia. I don't know that they've talked to each other. It'd be interesting to compare the two texts to see what they've come up with. But the Limoges group will be holding a conference later in this year to discuss their draft, and they're hoping to get governments interested in the possibility of adopting it. So I think those are my comments.
Also, very interesting comments on state responsibility and climate change, the disproportionality and of the impact on different groups and as well as states, the legal framework and the enforceability of international or the enforceability by international tribunals, the states of emergency and derogation issues, the transboundary issues and gaps there, all very interesting stuff. So we have at least 15 minutes for discussion, and I'm sure we have lots of questions. So I'd like to open it up to the audience and the participants. So I would just ask that you please identify yourself and any affiliation that you may be willing to admit to.
Thank you very much for your illuminating presentations. My name is Ben Kreider, and I'm with the Institute for the Study of International Migration at Georgetown University. And we have a transatlantic study team actually on this issue I'm involved with. It's funded by the German Marshall Fund. My question is, in the U.S. and around the world, there's a lot of kind of alarmist rhetoric about this issue. You quoted these figures, and people like Norman Myers have quoted much higher figures in the number of displaced up to half a billion or a billion. And I think there's kind of a danger of the securitization of this problem, portraying this problem just as one of security. We haven't been talking about that in this context. But I guess I'm wondering how in the U.S. This issue can be discussed in a way that makes it relevant to people, not just being afraid of millions of refugees kind of crashing the gates. What's the other way to frame this issue?
Sure. Well, I would hope that the discussion of it as an internal matter and using things like the comparison between the Oakland Hills and New Orleans would bring it home. The drought in the Southwest, I don't know if you remember in the last election, McCain said one of his platforms, if he got elected, president would be to redo the water allocation between California, Arizona, and others using the Colorado River. We're going to see this issue domestically as well, and I think, to some extent, we already have in the Massachusetts versus EPA case, partly an issue of who's responsible domestically, how's this going to impact businesses, what type of measures we could be taking here. People are displaced internally as well. I take your point, though, because I just answered an email this morning from the MacArthur Foundation asking me if I would come and discuss environmental security and what the MacArthur Foundation should be funding on this issue, and it was precisely on this topic.
Well, generally on security and displaced persons.
I mean, I cannot really comment on the U.S., but I would take the same approach, saying that is at least as much, maybe even more, our problem. I think their indications are quite solid, that it's much more a problem of internal displacement and cross-border. Second, I think it's important not to be alarmist, because then many people are not listening to you. That's why I always refuse to give any kind of figures and presented more of challenges we have to address. On the other hand, to get the attention, sometimes it's good to be a bit alarmist, but where to draw the line, and it's a fine balance.
One more thing that I just thought of in this respect. It's also an issue of public policy. Insurance companies have been among the leaders in terms of looking at climate change and their impacts. And you are starting to see now insurance companies refusing to issue policies for property in certain low-lying areas. Florida has now got the question of whether they are going to create a public insurance system for areas in Florida that may be impacted by stronger hurricanes or whatever. So it's something that I think really affects the domestic economy, and the insurance companies would be a good alliance, I think, to look at some of these issues.
Okay. Other questions? Diane?
Hi, Diane Paul, Brookings Institution. I wanted to follow up on that question because it's very interesting to read some of the discussions in the Human Rights Council and to see what the difference is between the discussions between the rest of the world, I guess you could say, in the United States and Canada on this issue. And both the U.S. and Canada are going to be confronting relocation issues relating to Arctic peoples. And that's an issue that's going to come up certainly within the next decade, I think, and is going to be very important in terms of possibly forced relocation unless there are a lot of negotiations ahead of time. And it's very important culturally and in terms of hunting grounds, hunting rights, land rights, mining rights, etc., mineral rights, and so on. And it seems that I know USAID is very seized of the matter. So, one idea might be to talk with the State Department about some of these issues, but it certainly does bring it home. On the issue of insurance companies, one of the things that's interesting is that insurance companies have actually been canceling people's policies also, which is very alarming, and hopefully we're going to see some litigation on some of these issues as well. But there's a lot of awareness raising, I think. Again, cautioning against being too alarmist, because that doesn't tend to do any good, especially because we have so many people in this country who don't believe climate change is even a real issue and don't even believe in evolution. So we have a lot of a long fight ahead of us, but I think awareness raising among the public and also bringing cases involved in the U.S. about drought, about what's happening to our people in the Arctic regions with the permafrost melting, what's happening to villages, hunters falling through the ice, and trying to make that more real for people might be one approach as well. Try to get the media to cover some of these issues in the mainstream media a little bit more. They have done some, but I think we can always use more exposure on these issues as well. Thank you.
You want to do a quick response, or we can just take more questions? We'll go with Joel Charney and then Jim Apple.
I do have something to say.
Okay.
Yeah, hi, Joel Charney from Refugees International. I mean, Walter, I think the way you've analyze the situation, I find, that resonates for me. I think it's accurate in terms of what the main legal gap is. And I guess I'm wondering if you have any thoughts or advice at this point on how do you see the best way forward in terms of closing the gap? Is it in the context of the climate negotiations? Should we be going for a convention? You'll recall that on the 50th anniversary of the Refugee Convention, the decision was made not to reopen the convention on the grounds that there would be fewer rights rather than greater rights. So I'm just wondering, in this context, with I think a plausible gap having been identified, if you have any sort of strategic thoughts in a way of what the best way is to close that gap for people who have to cross a border, due to factors related to climate change.
You can respond to that, and then we'll take some more at the end. Yeah, respond to that one.
Why don't we take them all?
Okay, we'll take them all. And then I saw Jim Apple.
James Apple, International Judicial Academy. What is the adaptation fund and how is it administered?
Okay. Anybody over
here? Jacques Bahati with Africa Faith and Justice Network. I recently was at a hearing at the House of Representatives, and there are some of the members of the House who are skeptical of the climate change. And I know in legal proceedings, before convicting somebody, you have to bring evidence. So are we assuming that you are on board with what's going on, or what the evidence are you bringing to this conversation for those who are denying the effect of climate change? Thank you.
in the back, all the way in the back.
Hi, Laura E. I'm a freelancer for Deutsche Welle. I'm just wondering if there's any cases where, if we look at projections for climate change, sea level rising, Bangladesh being low-lying, huge number of people would be displaced. Are there any laws or lawsuits or forums where people would then go to at this point, or any conventions that are being discussed at this point, where, for example, the people of Bangladesh, a huge population, would have some place they could go and make some sort of an appeal because they're going to be displaced due to climate change, and then who would they be going after?
Okay. All right, why don't we take those then? We have the legal gaps and closing this gap, the adaptation fund, evidence of climate change, and then different fora for people to assert their rights and seek remedies. So.
Well, regarding the way forward, I don't have a full-fledged strategy, just elements of it. And it's kind of two different steps. First, I think it's important to kind of get a consensus at the universal level that this is a topic that needs to be addressed. And that's why I'm focusing on the whole climate change discussion and the new instrument. I think it has a lot of value to push the idea that there should be a very general article in there. Not that this article will solve any of the problems, but it will provide us with kind of a basis then to go into the nitty-gritties, the technical details. Now, for the second step, in a way it's, to me, too early to really identify the proper forum. There are different scenarios what's going to happen post-Copenhagen. One scenario is that it will not be possible to really have a good, comprehensive instrument that will cover all the relevant aspects. But hopefully a consensus that the problem is serious enough to establish kind of a formal negotiation process, or rather a framework for negotiations to look at the different issues, be it forests, be it whatever, be it also displacement. So something a little bit along the lines of the WTO, which is also today looked at very much as a framework for negotiations. If this would happen, then certainly this would be a good place to do it, even though one would have to go beyond climate change. The big danger of this discussion is that people who are displaced by things like earthquakes or volcanoes will simply be forgotten because everyone is focusing on climate change. That's why I have my question marks for that. What are alternative possibilities? Certainly not to reopen the discussions about the Refugee Convention. Maybe a protocol, but even then I think it's, as I had mentioned in passing, a problematic approach. There is one big difference. In refugee situations, it's always a government having something against these people. And we should not assume in a disaster situation that the government in the country of origin is really going out against these people. There might be some cases, yes, we've seen them even looking at Myanmar, etc. But the normal case will be rather an inability and not an unwillingness to protect and assist people. And I think we would spoil the whole discussion if we would look at it from a refugee perspective and use XCOM, etc. I would rather say let's look at it from a human rights humanitarian perspective. So it might be something for the Human Rights Council, but again, very difficult because it involves a lot of issues linked to sovereignty, etc. To me, the most promising approach would be to start discussions at the regional level, because this is very much regional displacement. These are not people taking the plane to very far away parts of the world. What we have seen in the past, we have these cross-border movements, for instance, in the southern part of Africa, Mozambique, South Africa, Zimbabwe, etc. We have it Central America, the US. We have it as a reality, Bangladesh, India. So maybe starting with regional instruments would be more promising, because these people are simply faced with a real problem. So there is much more openness to discuss it. And then once you kind of have consensus regionally on some key principles, then you can bring it up to the universal level. Adaptation fund, it doesn't exist yet. The countries most affected in the Copenhagen process have said, well, of course we need to adapt ourselves. We need to switch from, for instance, crops that are rain-fed agriculture to crops that withstand droughts. It costs a lot. We need to reinforce our dikes. We need to build better roads, stronger roofs for schools so people can go there during the hurricane, the windstorm, and be safe. But this needs to be financed, and it has to be the North that has to finance it because they have caused it. They have come up with huge demands, if I recall correctly, 750 billion for this adaptation fund. And the North said, no way, that's way that's unrealistic. The EU has come up with some offer, which was quite substantial, but then again, still not sufficient. So this was the point number 2. The main point was mitigation, obligations on emissions, why Copenhagen failed. But the second reason was not the principle of the adaptation fund. Everybody agrees on it, but the amount of money to be put into that fund. The question on how to deal with those who doubt, that's a real challenge, I think. Just looking at the issue of, I'm focusing on displacement, I think for me the question is not, it's also important, and personally I don't doubt that it's to a large extent man-made, but as a legal scholar I don't have any opinion on it. That's not a legal issue, a legal question. So I'm more focusing on the fact of climate change and not so much focusing on the reasons for it. When it comes to state responsibility, it becomes very important, and we have to work on that, but I think we are not there. But it's very difficult for people to deny that there are bigger numbers of climate-related disasters. It's a reality. We have the figures. We have to improve on the statistics. And in fact, that's also a challenge, but it's being worked on. The IDMC, the Internal Displacement Monitoring Center in Geneva, has been looking at the statistics for conflict-induced displacement now over a period of more than 10 years. And they have quite solid figures. And they are now just embarking on looking at the figures of people displaced by natural disasters. For a first phase, sudden onset, but they also want to expand into slow onset. And I do think that there will have much more reliable figures and material over the next decade, and it will be much more difficult than just to refute that. But the question of whether it's man-made or not, which is mitigation, and then the consequences in terms of state responsibility, this will go on. But I would, as a strategy, start to not kind of make divisions, but say, let's at least agree on it's a real problem when it comes to the humanitarian consequences. And let's continue to fight over the causes, and let's do more research, more work to sensitize people, to convince them.
Okay.
But not wait for the big consensus on whether we need to use our cars less often and buy smaller cars.
Okay, a couple of other strategies based on past campaigns. One is to look for leadership countries. This is also impacting Australia and New Zealand, and while Australia is being very hostile, New Zealand is actually taking this issue very seriously and moving forward on who they're going to take, how many they're going to take, really trying to come up with a forward-looking plan to anticipate the problem among the Pacific Islands. So they don't want to be alone, which means they're going to be looking for other like-minded countries that might be willing to join in something with them. So I think piggybacking on efforts that these kinds of more progressive countries are doing to get an international solution would be very helpful. In the Western Hemisphere, this is a major topic with CARICOM, and that's half the membership of the OAS. 17 out of the 34 member countries are CARICOM members. And during the time I was meeting prior to the election to the Commission with the ambassadors of the different countries, every CARICOM country raised this question. They're very concerned about it. Well, that won't help unless they can get cooperation from the U.S. and Canada. How do they do that? What are the U.S. and Canada interested in? The U.S. is very interested in halting the shift in drug smuggling into the Caribbean countries. One of the things we learned through OSCE is issue linkage can really be a good way to move an issue forward. So I would try that. Keeping the pressure on as well. There was a case brought by the Inuit against the United States and the Inter-American Commission. They did an innovative thing, which was the case was declared inadmissible, and I think probably on the law rightly so. But they got a general hearing open to the public and the press on the issue of the impact of climate change on the Inuit, which is probably about as good as they could have gotten if they'd actually had the case declared admissible. And one of the outcomes was a 2008 resolution of the OAS General Assembly calling on the Inter-American Human Rights Commission to produce a study on the human rights impacts of climate change. So that's my first assignment for my new mandate. So any of you have information you want to give me, I'd welcome it. I agree with everything that's been said on the evidence. It's undeniable temperatures are rising, that debate perhaps some of the causes. But one of the things I would suggest is correct anybody who uses the term global warming. Because you get a cold snap like this and they go, see? insist it's not about global warming, it's about climate change, because the press has really caused harm by using the term global warming. Bolivia is holding a post-Copenhagen alternate conference that they've announced on the demands of the developing countries, so we'll see what comes out of that. On your issue about litigation, I know that Tuvalu and perhaps some other Pacific Island states have been shopping around for international lawyers to file a case at the ICJ against the United States. Case hasn't been filed as yet. Most of the lawyers, I think, who've been contacted have been fairly discouraging about the potential of litigation at this point. But who knows? It may come. It may be out there, provided that they get the resources and the lawyers to bring the case, or someone will.
Well, we've really gone over time. I don't want to cut into the lunch that ASIL is providing too much more. So just please join me in thanking our speakers, and I encourage you to ask them questions afterwards.